Hello, everybody. Welcome to the podcast. And today our topic is the future of outside IR35 contracting. We're here with Dave Chaplin and Maya Magel. And please, can I ask you to both introduce yourselves for the time being? Hello, Dave.
Oh, hi. Thank you for inviting me to this podcast. I'm Dave Chaplin. I'm the CEO of a tax compliance firm called IR35 Shield, and we help firms, agencies and contractors to remain compliant with the original intermediaries legislation and then the new off-payroll legislation. I've been involved with IR35 for the last 20 years. I help people defend cases. I've represented at tribunal. I advise politicians and government bodies on IR35. It's fair to say that I'm rather obsessed with the topic of IR35.
Thank you so much, Dave. No, I know you're Mr. IR35 in many ways, so I know that. Maya, uh, let me please, if you ask to introduce yourself too.
Hi, my name is Maya Magel. I'm chartered accountant. I have been working as accountant for many years and then moved into EPM side of the industry. Worked on various system implementations for almost 15 years. I also, interestingly enough, worked as a contractor for 13 years. So this is quite interesting topic for me as well. Thank you.
Thank you so much. My name is Tim Ahmed. I'm sure you know me out there. I would say 25,000 users in my network, but I would say I've just done a kind of analysis. 85% of my network are contractors, so this is very important for many people in various things. So I've known a lot of you out there who've, decided to do different things based on what's happened. But yeah, so let's go straight into the questions. The first question, Dave, going forward, what are the key requirements for contracts to be outside IR35? If a company rejects this, can we challenge them?
Well, I think we need to be careful with the word requirement for saying someone to be outside IR35. I mean, you cannot essentially apply window dressing to this area of law. You can't choose. It is what it is. You have to look at the status tests for deciding whether somebody is inside or outside of IR35. So typically we're looking to see if the relationship, when we take away the limited company and just look at the relationship between the individual and the company, without that personal service company in between, is that a relationship that's one of employment? And the typical tests are all based on something called ready mixed concrete. It's an area of case law, a particular case. So we want to know, is there personal service? Is there a sufficient framework of control? And is there sufficient mutuality of obligation? Some of that's quite a contentious area. And then there's other things we look at that are more secondary factors like financial risk, part and parcel, that kind of thing. So the typical person who is outside IR35, you have hired somebody to come in and do a thing. You've had a discussion about whatever that thing is before, the project of some sort. You've decided what it's going to be, the scope of the work, as a phrase lots of people are using at the moment, or the scope of the services. They come in and do that, and they only get paid for when they're doing that. You're unlike an employee is someone that you pay to have a job title and skills, and you're buying their time. And the obligation is that you'll give them work to do and they have to do that work. And if you don't give them work, you're still going to pay them. So there's subtle differences, but fundamental for deciding whether somebody is inside or outside IR35. We could talk about this for hours and hours, but that's the general idea. Now, in terms of a contractor rejecting a status, the word rejects perhaps doesn't quite align with the legislation. So we're talking about Chapter 10 of the Income Taxes Act. And in Section 61T, there is law, quite vague, that provides a framework so that a contractor can challenge a determination that has been given to the contractor that says inside IR35. Now, that's the theory. In practice, what we're typically seeing is that firms don't necessarily want to give out a determination that says inside IR35. they've already decided that that particular role is one that falls within the legislation. So they will just offer that as PAYE only, either an agency temp, or they'll be going direct on a fixed term contract. So we're not actually seeing many of these challenges. And even if the contractor is given a determination that says inside IR35, they are allowed to essentially dispute that, and they can give reasons for the dispute, why they think it's wrong. But then the client can just simply say, well, no, sorry, we've considered all of those reasons and we haven't decided not to change our decision. And most of the time, that's what happens, really. The legislation doesn't have much teeth. So in terms of rejecting the challenge, in reality, it's a case of you vote with your feet. And you go and find work somewhere else. And that's pretty much what we've seen across the board.
Thank you, Dave. Following from that, if the contract was outside IR35 and after that company decides to roll it and deem it to be inside IR35, what are the implications for the contractor and what would be the best action to avoid any investigation by HMRC? For example, leaving existing contract?
When you say rollout, are you referring to sort of what happened in April or just after any particular contract going forward now?
What I'm referring to, if the contractor until April was outside of IR35,
okay,
and when obviously legislation came to life, and company decides that the contract is no longer outside IR35 and now it's going to be inside, what are the implications for the contractors?
Well, the status can't magically change. We would probably say in law that before and after, the status was the same. The question is, did the contractor pay the correct amount of taxes or not? Remember, an opinion by the client after April is just an opinion. It's not binding in law. So the contractor, let's say in this example, had done their own determination before April. They're running off of Chapter 10, the original legislation. They've decided they're outside. They are dealing with their taxes accordingly, and they're not paying taxes as if they're inside. But then the client has formed an opinion after April that they're inside. So I guess the danger there is, and most contractors are worried about, what happens historically. Well, historically, the risk here is that the contractor got the determination wrong in the first place for all those years that they were with that client. If HMRC decided to open an inquiry, they would be asking the contractor questions and the client questions and doing an investigation. And in that scenario, the client is unlikely to be on the contractor side or agree with the opinion that they came to themselves. So if it was to then go to tribunal, the contractor is not going to really stand much chance of winning this case. So they're really up against it. So if they should probably get a third party opinion. And if they really think they were inside, then they should pay the taxes. And if they thought they were outside IR35 and the clients got it wrong, then they should be gathering evidence really and pack that away in case there is an inquiry in the future.
Thank you for that. This is kind of related, and I've seen it happen a lot. Won't name companies, but yeah, many companies are taking a blanketing approach. They're not really assessing each of the contracts per se, and they're putting everything inside of IR35. Are they breaking the law, and can we challenge them? Is there any redress for this?
Well, there are, when we talk about blankets, there's two types. There is a blanket ban of PSCs where they've just said, we are not hiring contractors who use limited companies. We will only hire people on payroll. That is not a blanket determination that everybody is inside. That is a commercial decision by that company to only hire people on payroll going forward. So that's the first thing. Now, if they are actually making blanket determinations, then that means that they have decided the contractors are inside IR35. They've produced status determination statements. that say inside IR35, they've possibly used role-based assessments. They have, as you say, used a sort of a grouping-based approach. They haven't considered the status on an individual basis. If they do that, they have not adhered to reasonable care. Now, because of that, it means that that status determination statement is not valid. If there's then an agency in the chain, the agency, having received that determination that isn't valid, has no right to deduct any taxes from that gross payment and can pay that contractor gross to their limited company because they are not the fee payer. So that's the legal position. The question then is, well, what is the agency actually going to do? Are they going to side with the contractor and say, well, actually, we think this one is outside, so we're going to pay them gross? Do they pay them, agree that it's inside and still pay gross anyway, and essentially stitch up the client? None of this is really helpful. The best solution there really is for the agency, if there is one involved in the contracts, is to have a sensible conversation about what's happened and dispute those statuses and see if they can come to resolution.
Thank you, Dave. So given this scenario, could contractors be investigated if it comes to that for all historic contracts, if they are to be investigated by HMRC and deemed to be obviously owing the tax to the HMRC?
Absolutely. Contractors can always be assessed historically for their tax position. Typically a standard HMRC can go back 4 years if they think the contractor has been careless, which is what you are if you don't exercise reasonable care. It's standard stuff. They can open up the inquiry window for 2 years. And then if the contractor is really naughty, where they know that they should have paid the tax, they maybe had a determination done historically that said inside, but they decided to just not pay the extra taxes, then that's deliberate, and HMRC can go back 20 years for that, and there's serious penalties and it's potentially even a jailable offence. Extremely unlikely in IR35 cases. Most of the time it's 4 years, and because it's so subjective, it's very difficult, and HMRC don't have much success in even proving that there's carelessness. If you sort of had a general go at it, if you're a contractor, then that's unlikely, but they can certainly go back 4 years, and they do. And there are cases ongoing at the moment, particularly in the media sector. There's lots of fallout from what happened after 2017. Whether that will happen in the private sector, we don't know. HMRC have indicated that provided people start paying taxes as they should currently, they won't go back historically, but given that there's possibly £1 or £2 billion on the table, I'm not sure that's a promise people should potentially rely upon.
Thank you. Now, I've seen this happen a lot in terms of the job posting at the moment, and it seems like everything is inside IR35. There's a limited amount of outside stuff going on. Should companies or recruitment agencies assess each contract individually before releasing the contracts on the job boards? What I mean by that is that it seems like everything is at IR35 inside. Is that, can we challenge them in terms of the job boards?
Well, I think what's happening there actually is the agencies are using perhaps clumsy wording to describe the fact that this is a role that is PAYE only. But they're saying, oh, it's inside IR35. If it's inside IR35, what that means in law is we want to hire you using your limited company on an inside basis, and we're going to deduct tax and pay your company net of tax. That's what that means in law. But what they actually mean is we're going to put you on payroll. We're not going to do determinations. This isn't outside IR35, it's inside. But again, the problem there is they've just done a role-based determination. They haven't assessed the contractor individually. So you could argue that reasonable care has not been met. You could definitely argue that. So when it comes to the actual payment of that contractor, and here's where a real danger can happen. Let's suppose it's the client has said, well, we would like to have all our contractors on PAYE. We think they're all inside, but then they don't issue any determinations. The agency could pay that money to, say, an umbrella company. The umbrella company is wary of the fact that inside IR35 used words have been used. There isn't any SDS. They could just pay that money gross to those contractors, and the client would be none the wiser. And then the client would be building up a large amount of tax risk because they're the fee payer in law, and they won't even have any idea. And when the tax has been found out to not be paid, the debt transfer legislation could kick in, and they could end up with a massive bill. So no one should be advertising these as inside IR35. They should just be saying, if they are PAYE only, this is a PAYE only role. Otherwise, there's all sorts of mess that could happen after that. In terms of challenging them, it's a case of you vote with your feet, or maybe you put your rate up. We've seen that in many cases where there's been huge rate inflation for those particularly difficult to find roles. At the lower end of the scale, it's vote with your feet, really, or it's like it or lump it. The pandemic has masked lots of the effect of rate inflation in some areas because lots of contractors were put on the bench. So yeah, there's probably not much you can do about it.
Thank you, Dave. So given that information, I believe maybe some companies may be concerned about implications of making wrong decision. What and how should they do this? And what are the additional risks?
This is the interesting bit, that companies appear to be, or have been, scared to death over the last few years. And we're not sure why, because I mean, we're at the coalface of this stuff, and we defend cases. We know how they're fought, and we know how to win them. We know why ones are lost. If a company has decided that that contractor is outside IR35, they've exercised reasonable care, they have some evidence to back up their determination, it's very difficult to see how HMRC could step in and win that case and say it's inside IR35. All of the parties are going to say, this is outside, this is the evidence, this is the reasons why. HMRC are not going to be able to come up with any counter evidence to prove otherwise. And whilst they can form an opinion based on just hearsay or just their own opinions, it won't be based on any evidential facts. So therefore, a judge just won't be interested. So there's actually, it's much easier to defend your position under the new legislation compared to the old. In the old legislation, the cases that are lost were lost by contractors where clients sort of said all the wrong things, really. And in many cases, those contractors were actually caught and they should have paid their taxes. And even then, in the last 10 years, HMRC only win about a third of cases. So there really is this massive disparity in terms of the fear and the actual risk that's in play. The next point to make on this is that if companies are using agencies and they give a status determination statement to the agency, they have got rid of their risk and passed it on to the agency. They're not the fee payer anymore. They don't hold any of the risk. It's the agency that holds the tax risk. So they've got rid of that. So it's surprising, actually, that so many companies have decided to take such a risk-averse approach.
Thank you. A lot of my friends and colleagues are now going abroad for contracts, and they believe, they're outside IR35, whether it's Europe, whether it's America. Even myself, went outside in terms of the regions. So is this a good strategy for contractors in terms of seeking contracts outside, or shall we just stick in brand UK and stay here?
Yes is the short answer on that. If you're staying tax resident in the UK and you wish to circumvent the new legislation, Chapter 10, and stay inside Chapter 8 land, which is the old legislation, then work for companies that are abroad and do not have any permanent establishment in the UK for tax purposes. There's lots of that going on. And ironically, it's going in the other direction as well, where because companies in the UK don't want to hire UK-based people because they have to deal with Chapter 10, they're hiring people from Europe to fill the positions. So we're in this bizarre situation where in order to get fair tax treatment and to have frictionless access to the market, there is a rule that sort of says don't work in your own country, which is just silly, really.
Thank you. Obviously, as the evolution of the workforce has changed and evolved, we're talking remote working, project-based delivery. Obviously, it seems that this is not fitting into IR35 determination process. Do you think that some companies are taking advantage of the situation in order to reduce costs by reducing the fees paid to contractors?
I don't have any empirical evidence to show this, but certainly anecdotally, we are seeing companies look at their situations and say, well, what's actually been going on here? They've looked at their workforces. Some of them have found lots of dusty perm tractors that have been paid far too much and been sat there as disguised employees for many, many years, and have decided perhaps to shake things up. We've seen some firms completely outsource their IT departments and push them abroad to India or Europe. So there's been all sorts going on. I don't think this is really going to work in the long term because we've seen it all before. We saw it all in the late 90s, early noughties when there was lots of outsourcing, and often you just need people in your own country in the office for the communicational side of things. There is definitely an advantage to having some of the workforce abroad if the rates are cheaper, but it's not really that cheaper. I mean, I'm thinking about IT. It's not actually that much cheaper really to get lots of things developed abroad. You can often find that things become rather messy and you end up having to do things twice. So I don't think this is something that will really be something to be concerned about longer term.
Thank you so much. Yeah, this is a very controversial question, but I'm going to ask it anyway. People have asked me for this question. Do you think companies are taking the simple route in terms of blanketing in order to divert investigation themselves? It's a subjective question, but not really easily answerable, I guess.
We're sort of a bit in conspiracy theory land here, aren't we?
Yeah.
So I mean, we certainly heard that when it was rolled out to the public sector in 2017, that HMRC went around and put the thumb screws on people, those public sector firms. They certainly can't do that in the private sector. But there are many firms that they just don't want to have inquiries. They want to be squeaky clean. They worry about their brand reputation. And they've just decided, okay, we'll just pay more for contractors. Now, whether that's going to be a viable long-term solution, we will see. I don't think it is. And when we get a couple of quarterly earnings cycles happen, companies are going to start to see that this is a really expensive way of attempting to do business. So the other thing that they will need to overcome is that actually there's not really such thing as the IR35 bogeyman. They don't need to be afraid of the dark, and it's perfectly manageable to hire contractors on an outside IR35 basis. HMRC are largely relying on the behavioural effect of everyone doing what they're supposed to be doing. Now, most of us, and that includes me and all my cohort of contractor friends, we work in an arena where contractors are proper contractors. They're not disguised employees. They haven't really entered into using limited companies just to avoid tax. They're not using managed service companies. They're not on low rates. There's no real avoidance going on. They earn more and they pay more tax. But we need to realize that actually there was this large underbelly in the market that was abusing limited company usage in order to avoid tax. It was going on. And that's really what HMRC has sought to close down. But along with it, it's taken a large part of the market that perhaps didn't need to be so fearful.
Thank you, Dave. Obviously, a recent IPSA survey concluded that around 12% of contract force is planning to stop working altogether because of the IR35 rollout. 17% are planning to seek an employment, and 11% are planning to retire within the next year, which is very interesting finding. Do you think this kind of marks the death of outside IR35 contracting in the long term?
Definitely not. And I think really HMRC will get what they want. They will get they thought a third of the market really should have been operating on an inside basis. And I think they're right. I think we have gone to a market where at least half are operating on inside now. There have been some reports that only a third are operating on an outside basis at the moment. But I think we will go back to around 2/3 of the existing cohort will end up being on an outside basis. I think it will take a couple of years to people to realize that actually this is perfectly manageable and not a problem. But some firms are very cautious. They like to see what other people do. And it's certainly not the death of contracting. When you look at all of the stats, particularly from staffing industry analysis, who run a very good statistical service, the growth is going to be in self-employment and contracting, whichever vehicle you do it. This is how firms work. Everyone's not going to start and become employees. That we need to have people that can roam around, work for multiple companies, share their expertise. It's the way to boost the economy. The government understands this, but it appears the Treasury don't. And whether they know they've caused considerable damage at the moment, we don't know. They would probably still deny it, but we're pretty sure they have done. But firms will come back from this and contracting will continue. And I really don't see there will be any problem at all.
Thank you so much, Dave. That's the end of our questions. It's been really interesting, thought-provoking. I would like to throw out these kind of questions out there. And if anyone out there, whether they're contractors, agencies, or companies, have further questions or things that they're trying to get off their chest, please contact me, and I'm more than happy to give these questions to Dave. We want to keep a long-term relation with Dave in terms of what's going on in the industry. There's a lot of things happening. I do know a lot of people are very worried in many ways. It's not just contractors, it's agencies, it's the companies, and even the big four, which are taking, maybe getting some advantage from this, but it is what it is. So the thing is, so please come back to me with anything. But thank you so much for your time, Dave, and also Maya. And thank you so much.
Very welcome. Thank you for inviting me.